Good morning. My name is Theron Solomon, and I am a partner at Dyller and Solomon. I am here with you today to introduce our guest speaker, my partner, Barry Dyller. Barry is the founder of the Dyller Law Firm, which is now, as of this year, Dyller and Solomon. Barry is a 1982 Stony Brook grad, where he majored in philosophy. He moved on to Boston University School of Law, where he graduated cum laude in 1985. He originally started his litigation career in New York at several big law firms, litigating big tobacco and dairy cases, just some of them. In 1992, he followed the love of his life and came to Wilkes-Barre, where he started in the public defender's office and started the Dyller Law Firm. Barry has tried well over 100 jury trials. He has been admitted into numerous courts, including the federal courts in New York and Pennsylvania, and the U.S. Supreme Court. He's on numerous boards, including for legal organizations, environmental organizations, and many others. He has numerous certifications, and awards. He has spoke on a number of occasions, from everything from qualified immunity to fee petitions to how to litigate civil rights. Barry was invited in 2013 to speak at the United States Judicial Conference in front of Congress, where he spoke on federal civil rights, federal civil procedure. Really, Barry is the originator of civil rights practice in northeastern Pennsylvania. Before him, it was not litigated here. There have been several that have tried, but no one quite the master like Barry. Barry's biggest skill, I think, is that, and what he brought to the legal community, is his ability to teach young lawyers and mentor other lawyers to achieve their full potential and to carry on the civil rights practice in law. He has made me swear on a stack of Bibles and everything else that I will carry this forward, and I will always do this. And we have a bright young lawyer, Tara Giratano, who's also going to help me carry Barry's flame forward, even though he's probably going to practice till he's about 95. So with no further ado, my partner, Barry Dyller.
First, I want to thank my partner for that very nice introduction. I'm not sure I can live up to it, but I will do my best to make this interesting and short. What do lawyers and judges do? How is law made? Not legislative statutes or regulations, but the infinite nuances that can only be made on a case-by-case basis, with the infinite variations of human behavior. I would like to examine a case of local interest involving conflicting claims of right. I hope through this discussion we can dig into the work of lawyers, judges, and the law. This case has received some local press as it arose here in northeastern Pennsylvania. It is entitled Mahanoy Area School District versus B.L. by and through her father, Lawrence Levy, and her mother, Betty Lou Levy. B.L. is Brandy Levy. I think we must be related, at least as of the time of the temple, since my family are also Levies. But no matter. Before I discuss the facts, let me warn you, the factual issue may seem petty. The principle is enormous. The issue is, how much may a public school control student speech or punish students for speech? But the issue is more subtle than that, as we will see. Brandy was a sophomore at Mahanoy Area High School. She was disappointed that for the second year in a row, she was put on the junior varsity cheerleading squad and not on the varsity squad. She believed it was unfair and that she had been lied to about the rules. Whether that is true is irrelevant to this case. But in frustration, Brandy used social media, Snapchat, on a Saturday at a convenience store she was at with her friend, not on school grounds, and posted a picture of herself and her friend with their middle fingers up and the words, F school, F softball, F cheer, F everything. She did not say F. Enough to make anyone clutch their pearls, or at least the Mahanoy school officials. The nature of Snapchat is that the picture and caption exist only for 24 hours and then automatically disappear. And it only goes to the people you have friended. But within that 24 hours, anyone with access can take a screenshot of the post and preserve it. That is what happened. Someone took a screenshot, gave it to the daughter of the cheerleading coach, and soon thereafter, Brandy was suspended for a year from cheerleading. So let's break down the facts as they relate to this speech. Let's look at the facts the United States District Court for the Middle District of Pennsylvania looked at. Our beloved, recently deceased Judge A. Richard Caputo, and also that the U.S. Court of Appeals for the Third Circuit heard. That court is home to our own Judge Max Rosen, also of blessed memory, and also to former Judge Thomas Vanaski, who has spoken at this Law Day event, this Law Day Shabbat, many times. And now the U.S. Supreme Court is looking at it, and having heard a 2-hour oral argument just this last Wednesday in Brandy's favor. The speech was not in school or on the school's campus. The speech was designed to disappear within 24 hours, similarly to when we speak to our friends or family. Brandy was not wearing any clothes indicating the school she was speaking about. This was not any kind of school-sponsored event. This was private speech, albeit visible to her 250 chosen friends. In the school's favor, the speech did get back to the school. The speech was discussed at school. Cheerleading teams must rely on each other for morale, and perhaps more important, for the teammates' physical safety. And school coaches traditionally exercise control over their athletes. Brandy and her parents sued the school district. They first obtained a preliminary injunction requiring the school to let Brandy continue in cheerleading. Soon thereafter, the trial level court, Judge Caputo, rendered judgment in Brandy's favor, awarding a permanent injunction, nominal damages, and an award of attorney's fees. The school district appealed. The Court of Appeals unanimously affirmed the district court. In other words, 4 federal judges all agreed that the school had violated Brandy's First Amendment speech rights by retaliating against her for her exercise of those rights. In the vast majority of cases, this would end the case. Most parties who lose in the Court of Appeals lick their wounds and go home. And even for those who dare to ask the Supreme Court to exercise its discretion to hear a further appeal, the Supreme Court only agrees to hear a tiny fraction of those cases. But the Supreme Court granted certiorari. In other words, it agreed to hear a further appeal. It is fascinating, just looking at the Supreme Court docket. Not only did Brandy's lawyers, and now there was a very large team, and the school district's lawyers, also a large team, file legal briefs, but a whole host of other parties filed amicus, in other words, friend of the court briefs, for both sides. Even the United States Justice Department filed an amicus brief supporting the school, and even was permitted to argue its position to the court during oral argument. That the Supreme Court took this case could mean that it wishes to reverse it. It is always bad news for the winner in the Court of Appeals if the Supreme Court agrees to hear a further appeal. I will try to summarize the parties' arguments. I will also comment on the Supreme Court justices' comments. But in no way can I predict the outcome of this case. Whatever I say will surely be wrong. Before discussing their arguments, both sides heavily discussed a case from 52 years ago, Tinker versus Des Moines Independent School District. In Tinker, the Supreme Court held that students could not be punished for wearing black armbands in school to protest the Vietnam War. The court discussed that students have First Amendment rights, but those rights are limited if they are likely to cause substantial disruption within school. Tinker is the backdrop for this case, and a reminder that we look to the past for how to deal with new situations and new disputes. The school district, having lost below, goes first. Here is a quote from the school's brief. Under familiar concepts of due process and notice, no off-campus speech is within school's ambit unless students direct their speech at the school community. And schools cannot use their authority over school discipline as a backdoor route to censorship. The backstop is Tinker. Schools can never punish speech solely because of disagreement with the student's message. No matter where the speech happens, students can express pro or anti-Israel views, praise atheism or urge prayer, or offend their classmates, close quote. Wait, this sounds more like an argument for the speech, but it was not. I think this illustrates how subtle the argument against the speech must be, the fine line the school will ultimately urge the court to take. Later, the school spells out its position. Quote, students do not check their First Amendment rights at the schoolhouse gate. But the First Amendment is not a territorial straitjacket that forces schools to ignore speech that disrupts the school environment or invades other students' rights just because students launched the speech from 5 feet outside the schoolhouse gate, close quote. In other words, the school says it does not matter where the speech originated as long as it has an effect inside the school. What does Brandy say? Many things. But in essence, Brandy says the school's argument is nonsense. I quote, the school's only limitation that the speech be directed to the school and reasonably likely to reach it is defined so broadly that it would encompass all speech to another student, no matter its content, and all content that is school-related. For young people whose contacts are primarily classmates and for whom school affairs are a frequent topic, that is no limit at all, close quote. Before we discuss what the Supreme Court's reaction was, let's think a little about speech. Why is it important? How can a 14-year-old blow off steam if she cannot speak negatively about a topic that is important to her? How can she express that she thinks she is being treated unfairly? Must it all be kept bottled up? Must she use only polite words? The real question, I think, is how far can a school reach outside of school to control the speech made that might affect or be about school? On the other hand, how do we balance that right and need to speak out against a school's interest in controlling its on-campus activities? A few comments from the justices. Justice Thomas, who almost never asks questions, on campus or off campus, a post on social media can be permanent and therefore seen in class. Justice Kagan, if things outside of school can also cause disruption, why shouldn't the school be allowed to address them? Justice Kagan again, the school's proposed test would make a large swath of off-campus speech fair game for school discipline. And the speech involved here was, in Justice Kagan's words, pretty generic. Justice Alito, the school's proposed rule is too vague and would seem to cover much speech outside of school. Justice Barrett, wasn't the punishment too severe for such off-campus speech? Justice Breyer, there was no evidence of, in quotes, material and substantial disruption that Tinker requires. Justice Sotomayor, how did this snap cause substantial disruption? I love an argument like this. It does not appear to be ideological. It is our justices at their best, struggling for a workable rule that protects multiple interests. Perhaps this is why our Supreme Court exists. It is over most of our pay grades. From what I can gather, the court itself is uncomfortable making some grand pronouncement in this case. I expect a very narrow decision on the facts of this case only. I think it will be very difficult for the court to craft a coherent, all-encompassing test for schools across the country to be guided by. This is law. This is the nuance we train for and expect from our brightest lawyers and judges. Thank you.